So imagine you're the lawyer, right? You're drafting a complaint.
Oh, always a high-stress moment.
Yeah, exactly. And you win. You go through this grueling federal trial. The jury awards your client $30,000. And as the gavel comes down, you suddenly realize something absolutely terrifying.
Let me guess. The original demand.
Yes. Your initial demand of $90,000, this number you just sort of put on the paperwork years ago, was literally the only reason the judge didn't throw your entire case in the trash on day one.
It really is a wake-up call for a lot of people because federal court isn't just about, the pursuit of justice.
Right.
It's essentially this high-stakes, highly specific game of math and logic. And if you don't know the rules of the gatekeeper,
You're out.
yeah, your arguments will never even be heard. You're dealing with a system that is, frankly, actively looking for a reason to kick you out.
Which brings us to our mission today.
Yeah.
Welcome to this deep dive, everyone. We are going to conquer one of the most, I'd say, heavily tested and strategically complex areas of law for you to understand.
Oh, absolutely.
We're talking about the amount in controversy requirement for diversity jurisdiction, specifically under Title 28 United States Code, Section 1332.
A classic.
Right. And we have an excellent stack of sources on the table to help guide us through this. We're pulling from two really dynamic study guides today. One is called Legal Minds, and the other is Mastering the Diversity Jurisdiction Amount in Controversy Requirement.
Both are great resources.
Yeah, they really are. So by the end of this conversation, you're going to understand exactly how this machinery works and, more importantly, why it was designed to trap the unwary.
Because there are a lot of traps.
Yeah.
But before we dissect those traps, let's establish the baseline rule, because this is where the first fundamental mistake usually happens.
Right, setting the stage.
Yeah. We're going to be talking extensively about a $75,000 threshold today, but you have to remember that this bouncer, so to speak, only stands at one specific door.
Diversity jurisdiction.
Exactly. Diversity jurisdiction. That's when you're relying on the parties being citizens of different states to get into federal court.
And the logic there, I mean, that's rooted in the fear of bias.
Yeah.
Right? Like, if you're a citizen of New York being sued in a Texas state court by a Texan.
You might be a little worried.
Yeah. There's this historical fear that the local judge or the local jury might favor the hometown party. So the system provides a neutral federal forum.
Precisely. Diversity jurisdiction exists to protect against that out-of-state bias. However, and this is a big Ferris, however, if you're suing under federal question jurisdiction, the rules change.
Meaning your lawsuit arises directly under a federal law.
Right. A federal law, the Constitution, a treaty, that's governed by Section 1331, and there is no general amount requirement there at all.
Oh, interesting. Because if you're arguing a federal right, the federal courts are just fundamentally the correct venue.
Exactly. Regardless of the price tag.
So if you have like a civil rights claim or a federal trademark issue and it's only worth $5,000, the federal court's doors are wide open for you.
Wide open. But the moment you rely on diversity of citizenship, suddenly this financial threshold becomes the absolute gatekeeper.
Which, I mean, that makes sense. If they let every minor fender bender between drivers from different states into federal court,
it would be chaos.
yeah, the system would completely collapse under the weight of the docket.
Right. So the amount in controversy requirement is essentially a pressure valve. Congress set it to ensure that only substantial disputes consume federal resources.
And since 1996, that statutory valve has been set at $75,000.
Yes.
Okay, let's unpack this. Because if we look at the actual text of the statute, there's a massive trap hiding in plain sight.
There is.
We need to know exactly what the threshold is and, critically, when we measure it. The sources emphasize one specific word in the statute, and that word is exceeding.
That is the magic word. The statute requires the matter in controversy to exceed the sum or value of $75,000. It explicitly does not say $75,000 or more.
Right, which means exactly $75,000 fails.
Fails completely.
$74,999 fails. You need $75,001.
You have to clear the bar, not just touch it.
It's like a roller coaster height requirement. You have to be taller than the line. If you're standing exactly flush with the line, they don't let you on the ride.
That's a perfect analogy. It's a bright line rule, and you have to think like a gatekeeper. If the line is drawn there, anything flush with the line gets rejected.
Okay, so that strictness makes sense. But the timing of when you apply that strictness, that's where the strategy really seems to come into play. When does the court actually calculate this math?
That's the million-dollar question. Or, well, the $75,000 question. The rule is that the amount is measured exactly at the time the lawsuit is filed.
So it's just a snapshot.
Exactly. It's a snapshot rule. The court looks at the controversy the exact second you hand over the complaint, whatever happens after that moment.
Even if things change wildly.
Even then, whether the value of an asset drops or the jury awards a lower amount, it does not retroactively destroy jurisdiction.
And this brings us right back to that scenario we started with. A plaintiff sues for $90,000. They get through the doors. The trial happens.
Right.
When the dust settles, the jury comes back and says, okay, the defendant is liable, but the actual damages are only $30,000. The text makes it incredibly clear that the federal court does not lose subject matter jurisdiction.
They do not.
Which initially sounds so counterintuitive. If the case was only ever worth $30,000, you'd think it shouldn't have been there in the first place.
It does sound counterintuitive, yeah, until you look at the underlying mechanics of judicial efficiency. I mean, imagine the alternative.
Okay, lay it out for me.
Imagine litigating a complex case in federal court for 2 years. You complete discovery, you hold a full jury trial, you get your $30,000 verdict, and then the judge says, well, you didn't hit the threshold. This court never actually had jurisdiction. The entire trial is void.
Oh, wow. Go start over from scratch in state court.
Exactly.
That would be a complete nightmare for everyone involved. It would essentially make every federal trial a gamble on whether the court even had the right to hold the trial in the first place.
Precisely. The system prioritizes finality and efficiency. Once jurisdiction is properly established at the entrance, at that exact moment of filing a later, lower verdict does not defeat it. The snapshot protects the investment of time and resources.
Okay, I follow the logic on efficiency. But if you're a strategic plaintiff's lawyer, you're immediately going to spot the loophole
The
here.
lawyers always spot the loophole.
Right. If the court only checks the amount at the entrance, and they don't care if the final verdict is lower, what stops a plaintiff from just standing on their tiptoes? What stops you from looking at a $50,000 claim and just writing $80,000 on the complaint to get past the bouncer?
This is where the tension of the system really reveals itself. The general rule is that the plaintiff's good faith allegation controls.
Good.
Yeah. If you, as the plaintiff, claim $100,000 in good faith, the federal court is going to accept your number at the door.
Even if the defendant is screaming that the claim is highly inflated and barely worth $20,000.
Even then, the courts fundamentally do not want to hold a mini trial on damages just to figure out if they have the jurisdiction to hold the actual trial. They defer to the plaintiff's good faith estimate.
But there has to be a limit.
Right.
I mean, I can't just claim $1 million for a paper cut, say I'm doing it in good faith, and get a federal judge to rubber stamp it.
No, you can't. And that is where the shield of good faith runs directly into the sword of the legal certainty test.
The legal certainty test.
Right. Your $1 million paper cut wouldn't survive because it would appear to a legal certainty that recovery above $75,000 is impossible. The good faith allegation only controls unless the law clearly prevents you from recovering that much.
So it's not a factual investigation at the door, it's a legal one. The court isn't asking, do we think a jury will give you this much? They're asking, does the law even allow a jury to give you this much?
That distinction is crucial. Let's look at the specific traps the sources highlight where legal certainty blocks the plaintiff. Imagine a state statute that explicitly caps damages for medical malpractice at $50,000.
Okay.
You can sincerely demand $1 million, but the law legally prevents you from ever getting more than 50. Therefore, to a legal certainty, your claim cannot exceed the threshold.
Right, because the ceiling is baked into the law itself.
Yeah.
And I imagine the exact same logic applies to contracts.
That does.
Like if two businesses sign an agreement saying liability for a breach is strictly limited to $40,000, it doesn't matter how mad the plaintiff is or how much they suffered. The legal ceiling is capped by their own contract.
Yes, contracts are a classic example. Another heavily tested scenario involves punitive damages.
Oh, I bet people try to use those all the time to inflate the numbers.
Constantly. Plaintiffs often try to rely on punitive damages to vault over the $75,000 line. But punitive damages only count if they are legally available for the type of claim you're bringing.
Which isn't always the case.
Right. For instance, in many jurisdictions, you cannot get punitive damages for standard breach of contract. So if your actual damages are $40,000 and you casually add 40,000 in punitive damages to cross the
The
line,
judge is going to catch that.
the judge will look at the law, see that punitive damages are legally unavailable, and dismiss the case. You fail the legal certainty test.
Here's where it gets really interesting, though. So if a plaintiff realizes their base claim naturally falls short, and the legal certainty rule prevents them from just making up a massive number, their next strategic move is going to be padding the bill.
Padding the bill, yes.
It's like if you're ordering food and the meal is $70, you start looking at the delivery fee, the taxes, and the tip to hit that $75 minimum for a coupon.
A very relatable analogy.
Right. Can a plaintiff use the extra fees that naturally pile up in a lawsuit to cross the threshold?
They cannot use the standard fees. The statute explicitly says the amount must exceed $75,000 exclusive of interest and costs.
Exclusive of interest and costs. And if we think about the mechanics of the snapshot rule, that actually makes perfect sense.
How so?
Well, ordinary litigation costs, like filing fees or paying a court reporter, those accrue during the litigation. And ordinary interest builds up because of the delay in getting paid while the lawsuit happens.
Right.
If jurisdiction is measured at the exact moment of filing, you can't logically use future costs that haven't happened yet to establish your value at the door.
That is a great way to synthesize it. The snapshot requires a fixed value, not a rolling tally. So ordinary interest and costs are strictly excluded.
But what about the massive big-ticket items? What about attorney's fees? Those are technically costs, but they can easily dwarf the actual damages.
Attorney's fees can count, but with a very strict caveat. You can't just throw them in because litigation is expensive.
Okay, what's the rule?
Attorney's fees only count toward the amount in controversy if they are recoverable by a specific statute or by a specific contract provision.
Got it.
If the law or the contract explicitly states that the prevailing party is entitled to their attorney's fees, then you can add your estimated fees to the mathematical pile. If there is no specific authorization, they are totally invisible for the jurisdictional calculation.
That brings up a really sneaky trap from the MBE study guides regarding how you frame your arguments. Let's say you buy a car, it explodes, and you suffer exactly $50,000 in property damage.
Okay, a $50,000 exploding car.
You sue the dealership, and in your complaint, you plead 3 alternative legal theories. You sue for negligence, you sue for breach of warranty, and you sue for fraud.
A classic shotgun approach.
Right. And each theory asks for that $50,000. Can you argue that 3 theories times $50,000 equals $150,000, getting you comfortably into federal court?
You absolutely cannot. This is a trap that catches a lot of people. Alternative theories for the same injury do not stack.
Because it's basically a choose-your-own-adventure to the exact same check.
Exactly.
You only have one exploding car. You only suffered one $50,000 loss. You're just giving the judge 3 different legal justifications for why the defendant should pay you. You aren't going to recover 3 times. Your claim is still functionally worth $50,000.
Perfectly stated. The court looks at the actual injury, not the number of paragraphs in your complaint.
So if mathematical padding with fees or alternative theories fails, the plaintiff's next logical move is to look around the room for help.
Seeking reinforcements.
Yeah. If I can't get there alone, what if I combine entirely different claims to hit the threshold? The sources call this the aggregation game.
Yes, aggregation. This is one of the most critical areas because the rules flip drastically depending on exactly who is doing the combining.
Let's start with the simplest scenario.
Okay, the most permissive rule. That applies when you have one single plaintiff suing one single defendant. If you are one plaintiff, you can aggregate all of your claims against a single defendant, even if those claims have absolutely nothing to do with each other.
Wait, I really want to push back on that, because doesn't that blow a hole in the entire philosophy of keeping minor cases out of federal court?
It sounds like it, doesn't it?
Yeah. You're saying I could sue someone over a $40,000 car crash, and then, in the exact same lawsuit, add a completely separate, totally unrelated $45,000 copyright dispute I have with that same person, just to get my total up to $85,000.
You can. It totals $85,000, which strictly exceeds the threshold. You are in.
That seems wildly at odds with the gatekeeping function.
It does seem like a loophole, but it comes back to that underlying principle of judicial efficiency.
Efficiency again.
Always. The federal rules view this as a package deal. If these 2 specific individuals who are already diverse in citizenship are going to be dragged into federal court anyway, let's just resolve every single legal dispute they have against each other in one room at one time. It clears the board.
Okay, I see the logic. It's a localized deficiency.
Hmm.
But I imagine the moment you start adding more people to the mix, that permissive rule vanishes.
It slams shut. If we connect this to the bigger picture, let's look at multiple plaintiffs. Say you and your friend are both injured in the same exact accident by the same defendant. Your friend has a $50,000 claim and you have a $40,000 claim.
Instinctively, you'd think, we were in the same car, let's pool our money to hit 90,000.
And instinctively, you'd be wrong. The general rule is that multiple plaintiffs cannot aggregate separate, distinct claims. You each suffered your own individual injury. You each have to independently cross that $75,000 line.
So 50 plus 40 does not equal 90 in this scenario.
No, it just equals two plaintiffs who belong in state court.
Unless is there an exception? What if the injury isn't separate?
You're anticipating the exact carve-out. You can aggregate if the multiple plaintiffs share a common and undivided interest.
Like a jointly owned asset.
Exactly. The classic example is a piece of property owned by two siblings. If someone damages that property, reducing its value by $80,000, the siblings aren't bringing two separate $40,000 claims.
Right.
They are suing together to protect a single, indivisible right in the property itself. That single shared interest clears the threshold.
I imagine that exact same logic of indivisibility applies if we flip the parties. One plaintiff suing multiple defendants.
Yes, it does.
If I have a $40,000 claim against defendant A and a separate $40,000 claim against defendant B, I can't combine those.
Correct.
But if they are jointly liable for a single injury, say they acted together to cause me one $80,000 harm, I can get in. Because I'm not really adding claims. I'm asserting one massive claim that they're both on the hook for.
You've got it. It's about whether the legal right or liability is fundamentally singular or separate. But there is one major lifeline mentioned in the materials for multiple parties that we have to discuss.
Oh, supplemental jurisdiction.
Yes.
Right. So what if I have a massive claim that easily clears the threshold, say $100,000, and I get past the bouncer? But my co-plaintiff has a related claim from the exact same incident that's only worth $40,000. The bouncer let me in? Can I hold the door open for them?
Yes, often you can. If Plaintiff 1 independently satisfies the amount in controversy requirement, Plaintiff 2 might get their related smaller claim in via supplemental jurisdiction. The federal court basically says, since we are already hearing this major case, it makes sense to hear this smaller, closely related case at the same time.
But the sources put a massive flashing warning label on this regarding diversity.
They absolutely do, and it is vital for you to understand this distinction. Supplemental jurisdiction can help cure a defect in the amount, but it usually cannot cure a lack of complete diversity. If holding the door open for Plaintiff 2 means that suddenly there is a plaintiff and a defendant from the same state, the entire house of cards collapses. Complete diversity is destroyed, and the federal judge will kick everyone out. You cannot use supplemental jurisdiction to bypass the citizenship requirement.
Okay, so we spent this entire time talking about damages, fees, and piling up dollars. But what happens when the lawsuit isn't about money at all?
Right, equitable relief.
Yeah. What if you're suing because you want a court to force someone to do something or to start doing something, an injunction, or a declaratory judgment where you just want the court to clarify your rights? So what does this all mean? How does a federal judge put a price tag on a command?
They apply what's known as the object of the litigation test. The court takes the equitable relief you're asking for the action you want them to take, and they translate its economic value into dollars and cents.
How does that actually work in practice, though? If I want an injunction to stop my neighbor from enforcing a restrictive covenant that prevents me from building on my land, how is that priced?
You look at the financial impact. If that covenant is enforced, it might lower your property value by $100,000. In that scenario, the economic value of the injunction to you, the plaintiff, is $100,000. You clear the threshold.
But there are two sides to every injunction. What if the injunction is only worth $10,000 to my property value? But forcing the defendant to comply, maybe they have to tear down a massive custom-built structure, would cost the defendant $200,000. Whose viewpoint matters?
That is one of the most fascinating gray areas, and it genuinely depends on which federal circuit you are standing in. Some courts adhere strictly to the plaintiff's viewpoint. They only care about the value of the relief to the person asking for it.
Okay.
Other courts look at it from the defendant's viewpoint. And many courts have adopted an either viewpoint rule.
Which makes sense under the federalism logic. I mean, if the injunction is going to cost the defendant $200,000, that is a substantial dispute. The federal courts should probably care about it, regardless of whether the plaintiff benefits that much.
Exactly. If it costs either party more than $75,000, jurisdiction is met. For anyone analyzing this, the key takeaway is knowing that the court will actively assign a monetary value to the equitable relief based on the economic realities of what is being demanded.
And I imagine for declaratory judgments, it's the exact same logic. You just look at the underlying asset or liability being disputed.
Right.
If you're asking a court to declare whether an insurance policy covers a specific loss, and that loss is for $150,000, then the object of the litigation is clearly worth $150,000.
Precisely. You just find the underlying financial stake.
Man, this has been incredibly clarifying. The sources provide a fantastic attack sequence to recap all of this, and I want to lay it out for you to take away.
It's like a great checklist.
It really is. So, if you're facing a jurisdictional question, follow these steps. Step 1. Confirm we are actually talking about diversity jurisdiction, not a federal question.
Crucial first step.
Step 2. Ensure the amount strictly exceeds $75,000, measured exactly at the snapshot moment of filing.
Don't forget exceeds.
Right. Step 3. Trust the plaintiff's good faith estimate, unless it is legally certain they cannot recover that much.
Watch out for the statutory caps.
Exactly. Step 4. Strip away ordinary costs and interest, but check to see if statutory attorney's fees or punitive damages are legally available. And step 5. If you're aggregating, remember the permissive rule. One plaintiff can stack everything against one defendant, but multiple parties need a shared interest or joint liability.
That sequence cuts through the noise and keeps you safe from almost every trap the examiners or the courts will throw at you. But stepping back, observing all these mechanics, this raises an important question about the integrity of the system itself.
Yeah, it leaves you with a really provocative thought to ponder. Think back to the very first scenario we discussed. A plaintiff can demand $90,000, get past the bouncer, undergo a full federal trial, and ultimately win only $30,000.
Right.
And the federal court perfectly retains jurisdiction because the math was done at the entrance. If lawyers know there is absolutely no jurisdictional penalty for falling short at trial so long as their initial estimate passes that basic laugh test of good faith, doesn't this entire framework inherently invite lawyers to artificially inflate their initial damages?
The valid critique.
It's almost strategic malpractice not to aim high if you want to unlock the doors to a federal courthouse. It leaves you wondering how much of federal jurisdiction is actually built on hard objective math and how much of it is just, well, legally sanctioned optimistic guesswork.